Your DOC numbers 303316. You're here this afternoon seeking a commutation of your sentence. You were sentenced in Jefferson Parish, the 24th Judicial District, in June 2008 to life for an aggravated rape. Mr. Williams, is that information correct?
That's correct.
Mr.
Correct.
Thank you.
No, it's, I can hear you, but you can't hear me.
Now I can. How old are you?
56.
Okay, and how many years have you served on this offense?
But 17 years, about 4 months.
Okay, and what's your educational level?
I completed high school and got a culinary arts degree. I also have a cosmetology degree.
Without getting into too many specifics, tell me exactly, what went on? What are you in jail for? What did you do?
I'm in jail for alleged rape. I'm in jail for rape.
Okay, you said alleged. Is it alleged or did you do it?
No, I was saying I'm in jail for an alleged rape that resulted in a conviction that, for rape.
Yeah, did you commit the crime is what I'm asking.
Yeah, I regret doing the crime. I regret it.
You admit that you did do the crime. Okay, Max, what happened in 1993 in Salt Lake City, Utah? What were you convicted of over there?
I was in my 20s. I think it was a lewdness.
And what was that? What did you do?
Well, I was a door-to-door salesman, and
Understand that, but that don't make lewdness charge. I mean, what did you do? Why did they charge you?
they charged me with a lewdness because I plea bargained to it. Lewdness. I was demonstrating on one of my customers, and I marked on a shirt and took the nozzle of the bottle to remove the ink stain.
So you claimed you didn't stick your hand in her pants as she alleged.
No, I didn't.
Have you ever had a history of drugs?
No, I haven't, sir.
Have you ever used drugs?
I've used marijuana before.
Did you drink a lot when you were on the street?
But not too much at all. I don't like the taste of alcohol too.
You completed all 4 phases of drug sex offender treatment. Is that correct?
That's correct.
Okay. What did you learn in sex offender treatment?
Well, I just learned basically the stuff that they were teaching. I mean, it's not to control yourself. It's, and just control yourself and just, it's, I mean.
Okay. You've had 3 prior periods of supervision. All of them were closed satisfactorily. The sheriff is opposed. Your family is unopposed, and the victim is opposed. You've only had 5 write-ups since you've been in custody. Your risk is low. Your custody is minimum. Why should we consider letting you out after only 17 years on a life sentence?
Because I'm a rehabilitated man, and the only thing I'm interested in doing is just striving to become successful like yourselves one day. Doing something constructive, instead of destructive. I know I made a mistake and I lost a family as a result of it. Because that was my family. Me and the mother had known each other ever since we were 14. I was 14, she was 16 when we met. And we had been friends for years and years. And when Kenya came along, we got into a relationship when Kenya was about 2 years old. 4 years later, it resulted to this incident here, which I deeply regret because I lost family. That's the thing that affected me the most.
How do you think it affected the victim?
I think it affected that too. But I'm just being honest with you.
Okay, I have no further question.
Thank you, Mr. Freeman. Warden Falco, is there anything you can add to the conversation?
No, ma'am.
All right, thank you. Mr. Williams, do you have a problem with your vision?
My vision,
Yeah.
yes, I do. I was in a very, very serious fire about a year ago here at Angola at Camp D. And my eyes, it's the sunlight.
You're sensitive to light? Okay. I was just asking because I noticed you had the shades on.
Yeah.
All right.
Very sensitive.
Well, we're going to hear from the folks who have joined us today. First, we'd like to hear from Ms. Kenya Sanderford.
My eyes, it's the sunlight.
You're sensitive to light. You're going to have to mute one of your devices. Have the shades on.
You can hear me?
Yeah. Do you have the YouTube playing also?
I can hear.
No,
I can see.
I'm speaking to Ms. Sanderford. Ms. Sanderford, do you have the YouTube also playing?
Yes.
You'll have to mute that. Get that off. We're getting echo through the computer. Have the YouTube playing also?
I can hear.
You can hear me now?
Yes, ma'am, I can. Go ahead. I'm speaking to Ms. Sanderford. We're still getting an echo.
You can see me?
Ms. Sanders, we can hear you, but you have the device playing the screen. You need to end that stream.
You can hear me now?
Yes, ma'am, I can. Go ahead.
You want me to hit leave?
We're still getting. What does she need to do?
Ms. Strand, do you have a Google Chrome up playing the stream? You need to close out anything else besides Zoom that you have open.
Yeah, now you're muted. There you go. That's still open.
Ms. Strand, do you have a Google
Y'all can hear
Chrome
me
up
now?
playing the stream?
We can hear you, but we also hear the YouTube. Is the YouTube video playing in the back?
Zoom that you have open.
Yeah, it was playing. I can hear y'all now.
Okay, good. Now we can hear you and just you. So go ahead.
Yeah, I had it playing in the background.
Go ahead.
But yeah, I would like to see, no, I would not accept you going up for freedom. The reason being because you hurt me in so many ways. I don't even know who I am as a person to this day.
Yeah, Ms. Kenya, can you direct your comments to the board and not to Mr. Williams? I want you to talk to us.
Well, I don't even know who I am. I be trying to find myself in so many ways, and I don't know how. And I don't want another person to grow up like me and be hurt, confused, thinking, that was normal. You don't want nobody to get close to you. You don't trust nobody, So it's like, I just wouldn't want that to happen to another person, because I feel like a person like that can't change. Like, you can't change what you do or how you do it, then it don't make no sense. So no. And yes, I do forgive you, but I never forget. Never. And yes, speaking to the board, I did love this man like my father. That was the only man that I knew. And I don't even love my own dad because of this situation. And I don't even want him to be close to me because of this. So before another child of person get hurt, I don't accept. And I really wish you the best in life, but not in a freedom way. And that's all I have to say for today.
Well, thank you, Ms. Sanderford. I know how difficult it was for you to speak to us today. I know it took a lot of courage, and we do appreciate it. Ms. Hay from the DA's office, welcome. We'd like to hear from you.
Good afternoon, Margaret Hay on behalf of the Jefferson Parish District Attorney's Office. Just a few things that I'd like to draw to the board's attention. Ms. Sandifer, thank you for coming here and being brave and speaking today. Ms. Sandifer was the tender age of 6 years old when she was violated by Mr. Williams. I'd like to also draw to the board's attention that Mr. Williams, according to our records, Mr. Williams' prior offense that was referenced earlier in Utah involved a 12-year-old girl. I would also like to draw the board's attention to the fact that on Mr. Williams' application for this hearing, he did not include that prior part of his criminal record, only that there was a check cashing forgery. Mr. Williams was also arrested subsequent to this incident taking place for failure to register as a sex offender. Those charges were subsequently dismissed when he was convicted. And he also has a discipline while in prison for a aggravated sex offense. For those reasons, for the nature of the crime itself, for the very strong, rightfully so, victim opposition, and for the things that I have just pointed out to the board, the state would oppose any commutation of Mr. Williams' sentence.
Thank you. Thank you.
Thank you.
All right, Mr. Williams, is there a statement you'd like to make to the board to close it out for us?
No, I have no statement. I have no statement to make.
Okay. All right. Well, we are prepared to vote. We'll be starting with Mr. Freeman.
Okay, due to the serious nature of this offense, and you've only served 17 years of a life sentence, the victim opposition, and your prior criminal history, my vote is to deny.
Mrs. Jackson.
Mr. Williams, you still have some work to do. Until you can admit to yourself what you did to that little girl, you're never going to be prepared for release. There was DNA evidence on her body and in her body that came back, and you failed to accept any responsibility for that. You act as if nothing had happened, and you see the devastating effect that your actions had on her life. So because you're a child sex offender, because of the opposition from the victim and the DA, and the insufficient amount of time served, my vote today is to deny.
Thank you, Ms. Jackson. Mr. Roche?
Mr. Williams, you have an extensive criminal background. You've been convicted of 4 felonies. The victim is adamantly opposed to any clemency. The DA's office is strongly opposed. In 17 years is totally insufficient for raping a 6-year-old juvenile when you were charged with the responsibility, because you were dating your mother, of taking care of that individual, and you violated her. You have a lot of work to do, Mr. Williams, and you have a lot of attitude to change. And as long as you display the attitude you're displaying now, you will be denied. And my vote is to deny your request.
All right, Mr. Williams, I do concur with my colleagues. You have a lot more work to do. My vote today is to deny based on the opposition that's been expressed here today, your prior criminal history, and
Yep.
the insufficient time served. So today, sir, your
Can I
application.
make a statement, please?
No, sir, you've made your statement. You chose not to make one. Warden Falvey, we are done at your facility. Thanks for accommodating us. It is 3:02 p.m. We will adjourn.
All right, good afternoon.
What a difference it makes to have the assistant district attorney get up and make those statements. What a difference. This is part of why I always yell for it. I have the facts of his case, and I'll go over it with you soon. But if you didn't have those facts, you would have had no idea until she spoke. And then I just want to say this survivor, the idea of how brave she is to get up there and speak and to realize how selfless it was what she said. It was, I don't want this to happen to another person because people like this don't change. How is it so clear and evident to so many of us of how right she is when others, especially in Department of Corrections, don't understand it? This was his 3rd time he was caught, and we'll go through that in the legal docs. I love this man like my father. I forgive him, but I don't forget. She was 6 years old when her mother came home, opened the door, and saw this man on top of her. And I've said it, I'll say it again. It is not a mistake that this man married her mother. They do this to find access to their next prey. He has a life sentence. This hearing was only going to be where they would recommend to the governor to commute his sentence, to shorten it so it's not life anymore, so that he would have a chance at parole. He applied for it, and he's allowed to get it. That's the way the law works in Louisiana, apparently. And there are, it's the idea to think that maybe one day they will let him out. But I don't know if how many of you've seen of these hearings. We have seen plenty where they don't get life sentences. This is a kind of an anomaly. We have seen so many where they just get a little slap on the wrists. I mean, 15 years is on the high end. So they talk about, Mr. Freeman. I've grown to respect him more as time has gone on, and he's had his moments, but his interview style is pretty lacking. When he first said, "Oh, what did he do with the young woman in Utah?" And what do I think? I think there's a young woman. Then he says, "Oh, well, it was a misunderstanding." And it wasn't a young woman. It was two girls, like the assistant DA had brought up. Two separate occasions, two girls. And what he had done to them was terrifying. He was going door to door as like a salesman, and he asked if anyone was home, and he just went inside their home when they said no, and he basically like attacked them, and they ran away and locked themselves in their room. And very terrifying stuff. And somehow Utah didn't seem to give him that long of a sentence. I don't. But this is the court transcript of the case while we're here today, and they brought this up as preliminary information about, I think, why he got the life sentence. So they talk about how he had separate encounters with juveniles. In 1993, there was one incident that resulted in the defendant's arrest and a subsequent guilty of lewdness involving a child. And this is where, you have to say how nuts this is when you find out what he actually did to these children, that they allowed him to even plead down to get a short sentence when it's so clear that someone like this cannot be in society. And because of their leniency, he did it again. How is that possible? The prosecutor indicated she was able to obtain police reports and locate two women. This is women at the time who were referred to in the notice of intent. One of the women referred to in the notice of intent was AD, who was 13 years old at the time of her encounter with the defendant. Again, they're talking about pulling this information as references for this case. Great job on the DA, who did an excellent job bringing up proof that he has an habitual offender of this nature, doing her homework, making those, and then getting a life sentence versus other DAs. And then you can see it's the DNA of this case trickles down, the culture trickles down. The assistant DA showed up and made sure that she would show up. It's so important, so critical. But the prosecutor testified that she spoke to AD. After speaking to AD, the prosecutor learned that a man had come to her home, to AD's door in 1993, selling cleaning supplies. And he had asked to come inside to demonstrate this cleaning supplies. Well, AD said, sure. And then the man said, wow, you're pretty. I would love to lick you up if you were my girlfriend. This is what he told a 13-year-old. The defendant then stained her crotch area of her shorts and made overt and verbal gestures. Then, in an attempt to remove the stain, near her, down there. She became upset, told the defendant to leave the house, and then told a friend what happened, and they called the police. No legal action was instituted against the defendants, against the allegations. So nothing happened. They felt at that point, whatever, what's the big deal? It's just a child, right? The second, so he went and did it again, of course, who was 12 years old, encountered the defendant, and the prosecutor also spoke to GP, and GP and AD lived on the same street at the time. According to GP, the defendant knocked on her door and asked if she was alone and told her that he wanted to help her clean a stain off the carpet. So he came in the house. GP was bending down. The defendant told her to turn around. He then placed his hands on her buttocks, marked GP's with the stain, put his hand inside of her shorts, and rubbed her. GP, just God bless her, her little heart. She ran away and locked herself in the bathroom and yelled at the defendant to leave. She called a friend who called the police. How many ways that could have easily gone so differently? So he has two victims. Now this time, I wonder what they did anything, because of course you could see that it doesn't seem in Utah they cared that much. The first time nothing happened. The second time, I'm not quite sure, but I would hope that something would have happened. Then we have why we're here today, which is KS. Before Hurricane Katrina, she was living with her mother, and her sister also lived nearby. And that's when the defendant took down her pants one day and started licking and biting her. She testified. So they took this to trial, and and he said if she told her mother that he would then unalive her mother. So he threatened that to a 6-year-old girl. Then she did it a second time. And shortly thereafter, her mother found her in the bed with the defendant. So she went and called the police. Her mother testified that July 8th, 2005, she was living with the defendant and her daughter. And approximately 4:30 in the morning, she woke up and noticed that her apartment was completely dark. So this was happening under the roof with them all in the house at the same time. If you can imagine the lengths of what this monster went to, marries this woman with this child in the house at 4:30 in the morning with everyone home, after he now has done it at least 2 times, threatened that he was going to end her mother's life if she said anything. And then at 4:30 in the morning, the mother wakes up and notices the apartment's completely dark. I mean, what could be wrong, though, right? It was unusual because normally she kept the TV and bathroom light on. So she went into Case's room and turned on the light. And there he is. She is half naked and the defendant is butt naked, she testified. And she saw the defendant licking. Gosh, and I got to tell you, bless her mom's heart. She did what all of us would do, I think, was she grabbed the closest thing to her, a stick, and started hitting him in the head with it. And then she wrapped her daughter in a sheet or towel and left the apartment. And she called the police. I mean, I think if she had had even a stronger weapon on her at the time, it would have been okay, right? I wonder what they would have said. I think it would have. Who knows? But the daughter was taken to the hospital where a kit was collected. And they just go through more of the case. And it's just, well, I didn't realize this when I first started reading it. So one of the girls who testified at trial from Utah, which they brought to testify, and it's just incredible what lengths they go. The DAs will often just do these little plea deals of 5 years, 10 years, or 15 years and make these, but in this case, they're actually calling other witnesses who are, well, I guess at this stage, she would have been much older. And I don't know. But anyways, the final witness to testify was AD, one of the women referred to in the notice of intent. Remember, she was 13 years old when he came to her door selling carpet cleaning products. She told the man that she was home alone and eventually took the man to her basement. This is how this could have gone, where she recalled that there were stains on the carpet. The man squirted the stains on the carpet and told her to put her foot on the stain. He then told her to put her hips into it and grabbed her hips and moved them around. 13 years old. Afterwards, the man colored her shirt and put his hand underneath it and tried to scrub it out. According to AD, now this is where it's interesting. I mean, like, the man told her, if you were my, okay, she asked him to leave. When she left, she took her bicycle to her friend's house, and while she was riding home, she noticed the man sitting on top of her street in handcuffs. It was him. So he went straight to someone else. I'm confused about that. Or they no, they just cuffed him right there at the time from the phone call. I don't know how the police acted so quickly. The assistant AD was never specifically asked at trial whether the defendant who had assaulted her 15 years prior. The prosecutor asked AD if the complexion of the person was in your home, is it consistent with the person sitting in the courtroom? And AD replied, yes. The defendant did not testify at trial. I mean, well, that would have been up to the... So they're appealing that was the wrong... I mean, it would have been up to the defensive attorney, to the defense attorney to cross-examine the witness. I don't... It is interesting that they were able to bring up two priors as testimony at a trial. To me, that is interesting. I wonder, I mean, we've seen so many times where a judge would just say, you can't, it's inadmissible. It's a different case. You can't bring it up. But maybe it's only because I don't actually know. I wish I knew. or maybe because it was just a trial judge, and because they needed to get it aggravated, maybe if it didn't have multiple offenses, they wouldn't have gone for the life sentence. It would have just been one sentence, a short one. I don't really know. If someone does, please do provide commentary on that, and I'll leave the link in the description. But this is just obviously a very clear case about how this man can never be set free. I mean, there was nothing, there was not even like a fake trying sense of remorse. I deeply regret it because I lost family. That affected me the most. That was like his statement was like, there's nothing there. And I'm just being honest with you, board. I mean, there's nothing. He really doesn't get it. The idea that he can somehow have a chance of being free is unacceptable. Now, I like to think that he will never be free. He does have a life sentence. You would have to find some board to commute him. I don't think it's going to happen. I wish I could find more information about how much time, if any, he got in Utah. You know what? I probably could Google search the statute. Okay, I paused it, did the research, and found it. Felony for lewdness involving a child of the third degree has a maximum penalty of 5 years in Utah, at least as of today. And that would mean that after he had done that twice to 2 children, they allowed him to plead down, and he got just 5 years. And what do you think happened next? So there you go. It's not just Louisiana that is broken, but I suppose many other states, including Utah. You might not believe it if you didn't see it, and that's why we do this. With that, I'll let you go.